You are 31 years old and you are good at two things: reading people and making their mistakes go away. You learned the first skill at 19, working as a paralegal for a mid-sized firm in Chicago that handled white-collar defense. You sat in depositions and watched guilty men tell the truth in ways that sounded like lies, and innocent men tell lies that sounded like truth. And you realized that guilt and innocence were almost entirely performances. The second skill came later, more gradually, the way all dangerous competencies develop, through small escalations you didn't notice until you were already somewhere you couldn't walk back from. The night that changes everything starts the same way every other night does. You're at your desk at 11:40 p.m., reviewing a breach of contract dispute for a regional pharmaceutical company. It's dull work, the kind that pays your rent and keeps your student loans at bay and makes you feel like you're building towards something even when you're not sure what. Your phone rings. Unknown number. You answer because you always answer. That's another thing you learned early, that unavailability is a liability in this business. The voice on the other end belongs to a man named Gerald Holt. You know the name. Everyone in legal circles knows the name. He is senior counsel for Marin Capital, a private equity firm with $17 billion in assets and a reputation for making problems vanish before they become public knowledge. He tells you that someone you know, a junior associate at your firm, a man named Derek Chun, just sent a confidential settlement agreement to a journalist at the Financial Times. He tells you that Derek is panicking and that he made a call to you 3 hours ago from a burner phone and left a voicemail asking for your advice. He tells you that the voicemail has already been flagged. Then he pauses, and in the silence you understand that the pause is itself a message. You have 48 hours to make Derek's mistake go away, he says. After that, the journalist publishes. After that, the story is about Marin Capital, but the secondary story, the one about who knew what and when, is about your firm. And your name is already on the wrong list. You call Derek. He answers on the first ring, the way people answer when they've been waiting to confess. He tells you the journalist already has the documents. He tells you he thought he was doing the right thing. You tell him to stop talking and listen. You tell him to do exactly what you say, in exactly the order you say it, and that if he deviates even slightly, you cannot help him. He agrees. You begin. You spend the next 12 hours doing something most lawyers are never trained to do. You work backward from consequence. You don't ask what's legal. You ask what's possible. There's a difference, and the distance between those two questions is where your entire career will eventually live. By morning, the journalist has a retraction-adjacent message in his inbox from Derek, framing the entire exchange as a misunderstanding, a misdirected email, a documents folder sent in error, nothing more. By afternoon, Derek's employment status has been quietly renegotiated into a voluntary resignation with full severance and a non-disclosure agreement that has more teeth than a federal injunction. By the following evening, Gerald Holt calls again and says, simply, "You're good at this." 2 weeks later, you're sitting in the 43rd floor conference room of Marin Capital's Chicago office, and a man named Vincent Lau is across the table from you. Vincent runs operations for Marin, and he does not look like someone who runs operations for a $17 billion firm. He looks like someone who has spent 20 years making decisions in rooms where the wrong decision ends careers. He slides a folder across the table and tells you the compensation for your first formal engagement is $240,000, structured as a consulting retainer, fully compliant with tax reporting. He says, fully compliant, the way people say it when compliance is the least interesting part of the arrangement. You open the folder. You read the situation summary. You close the folder. You ask for 1 hour to think. He says you have 30 minutes. You take 25 and say yes. That is how it begins. Over the next 3 years, you become fluent in a language most people don't know exists. It has no name in any legal textbook. It isn't crisis management, exactly, or public relations, or legal strategy. It is all three collapsed into a single discipline that requires you to understand pressure, timing, and human psychology at a level that most professionals never reach. You learn which problems require speed and which require patience. You learn that the most dangerous mistakes are never the dramatic ones. They're the small, quiet ones that nobody thinks to look for until it's too late. You learn that billionaires don't fear the law the way ordinary people do. They fear the story. They fear the narrative that can't be controlled. That is the only thing that can truly threaten them. and that is the thing you become exceptionally good at destroying. Your clients are not all the same, but they have enough in common that you develop a taxonomy. There are the legacy wealth clients, old money, cautious, image-conscious, terrified of anything that might disturb the careful architecture of their public persona. These are the easiest to work with and the least rewarding. They pay well and demand little, and occasionally surprise you with the smallness of their crises. A senator's speech written 30 years ago that used language no longer acceptable. A private real estate deal that edges close enough to self-dealing that it could attract regulatory attention. You handle these the way a surgeon handles a routine procedure, efficiently, without emotional involvement, with no more force than necessary. Then there are the new money clients. The tech founders and fintech architects and private equity architects who built their fortunes quickly and without the institutional guardrails that slow legacy wealth accumulation. Their problems are larger, messier, and more structurally interesting. An acquisition that was based on due diligence you suspect was deliberately incomplete. An NDA that a former employee is threatening to violate not because they want money, but because they want the world to know something they believe the world deserves to know. A family member who has started talking, in private circles, about things they weren't supposed to witness. You move through these problems the way a chess player moves through the late game, seeing several moves ahead, sacrificing pieces you're willing to lose in order to protect the ones that matter. The hardest cases involve people who have done something genuinely, irreversibly wrong. You know going in that they did it. They know you know. The thing is never spoken between you because speaking it changes the nature of the engagement in ways that become legally complicated, and you are careful about legal complications in a way your clients sometimes find excessive. But the knowledge sits in the room whenever you meet, heavy and unacknowledged, and you have learned to work around it the way you learn to work around any permanent obstacle, not by removing it, but by never letting it determine your direction. You tell yourself, in the early years, that you have a line, that there are problems you won't make disappear because making them disappear would require erasing something that shouldn't be erased. You test this line more carefully than you expect. The first real test comes in year 2. A client, a man who made $4 billion building logistics infrastructure in Southeast Asia, has a situation involving a business partner in Jakarta who has documentation of a payment scheme that, if made public, would constitute a violation of the Foreign Corrupt Practices Act. The partner wants $15 million. The client wants the problem to go away for less than $15 million and with no ongoing leverage held over him. You structure a legal resolution that costs the client $9 million, transfers ownership of 2 subsidiary assets to a trust that the partner controls, and includes a mutual non-disparagement clause that ties both parties tightly enough that speaking publicly about the arrangement would cost the partner more than it cost your client. It works. Everyone is satisfied. 6 months later, you learn from a secondary source that the Jakarta partner was not simply a nuisance. He was a whistleblower. The payment scheme wasn't just a regulatory gray area. It involved systematic bribery of port officials that had a downstream effect on shipping competition in the region, and smaller operators who couldn't afford the same bribes had been effectively driven out of the market. The $9 million you structured kept that information buried. You sit with that for a while. You don't quit, but you sit with it. By year 4, your network is substantial. You know 3 former intelligence officers who now work in private information gathering and who can tell you things about a counterparty that no due diligence firm would ever surface. You know 2 forensic accountants who can trace money through holding structures with the kind of patience that makes prosecutors nervous. You know a publicist in London who handles reputational architecture for 6 of the 20 wealthiest people in Europe, and who owes you enough goodwill that a single phone call can either accelerate or quietly suffocate a story, depending on what the situation requires. You know a judge, not a corrupt judge, you tell yourself, just a judge who has a long memory for favors and a longer memory for the people who didn't extend them when they could have. What you have built, without fully intending to, is a system, and systems develop their own gravity. The situation that most clearly shows you what you've become arrives in a Tuesday morning call from a woman named Sylvie Chen, chief of staff, to a man whose name appears in enough headlines that you recognize it immediately. The situation is this. Her employer's 17-year-old son was involved in a road incident in Monaco 2 weeks ago. A motorcyclist was injured, seriously, possibly permanently. The local gendarmerie filed a report, but have not yet pursued charges because your client's legal team moved with enough speed to create reasonable ambiguity about the sequence of events. The motorcyclist, a 26-year-old French national, is currently in a rehabilitation facility and does not yet know the full details of what his legal options are. His family has retained a local attorney, but a local attorney in Monaco does not have the reach to pursue a civil claim of any real magnitude against a man whose assets are held across 14 jurisdictions. Sylvie Chun is not asking you to harm anyone. She is asking you to ensure that the motorcyclist's family receives a private financial arrangement that is genuinely generous, enough to cover all medical costs, all rehabilitation, a lifetime care stipend, but that arrives through a structure clean enough that no public record connects it to your client. She wants it done before the family's local attorney has time to research what a claim of this nature could actually be worth in the international courts. You listen to all of it without interrupting. You ask 2 questions. You say you'll call back within 4 hours. You spend those 4 hours not planning the operation, but deciding whether to take it. Because this is the version of the work that crosses the line you told yourself you had. This isn't protecting a corporation from regulatory exposure or managing the fallout from a clumsy acquisition. This is using your system, your network, your reach, your expertise, to ensure that a young man who was seriously hurt by a powerful family's child never fully understands what his legal rights are worth. The settlement will be real. The money will be real. He will be taken care of in a way that most injured people in his position never are. But he will never know the full picture, and the full picture would have been worth more. You call Sylvie Chin back in 3 hours and 50 minutes. You take the case. You tell yourself it's because the settlement is genuinely fair, and you believe it's fair, and you spend the next 6 weeks making sure it is as fair as you can make it within the constraints you've been given. You structure the arrangement through a charitable vehicle so that it arrives with a framing that dignifies the motorcyclist rather than erasing him. You insist, and this is the closest you come to a hard line, that the medical trust is unconditional, that it cannot be revoked, that it is not tied to any ongoing silence obligation beyond the standard non-disclosure on the source of funds. You make the young man's care as secure as you know how to make it. It is the best version of a thing that probably should not have been done at all. That is the work. That is what you do. You are not the person who commits the wrongs. You are the person who ensures that the wrongs never fully become the story, and that the people who commit them continue to operate in a world that functions on their behalf. You are the infrastructure of impunity, and you know it, and you are very, very good at it. In year 5, you have 11 primary clients. Your annual income is structured across 4 entities in 3 jurisdictions and is, technically, fully compliant. You have a small team, 2 researchers, a communications specialist, a retired FBI analyst named Dale who handles the information gathering work you prefer not to do yourself. You have a philosophy. Every problem has a solution that costs less than the problem, and your job is to find it faster than anyone else and implement it more cleanly than anyone else would bother to. You have a reputation that exists entirely by word of mouth and cannot be Googled and is, in its own way, the most powerful reputation in any room you walk into. You have also made 11 enemies. Some of them are the people your clients hired you against, attorneys who found their leverage quietly neutralized, journalists who found their sources suddenly unavailable, partners who found that the leverage they thought they held was somehow, inexplicably, less valuable than they had believed. Others are within the system you operate inside, fixers who worked for your clients before you did and resent the displacement. One of them is a man named Harris Weld who fixed problems for Vincent Lau at Marin Capital before you did, and who has spent the last 3 years building a file on your operations that he believes is extensive enough to create serious problems for you if he decides to use it. You know about Harris Weld's file. You knew about it before he knew you knew, which means you've had more time to think about it than he has. You have not neutralized it because neutralizing it would require doing something to Harris Weld that you haven't yet decided you're willing to do. So instead you monitor it. You know when he accesses it. You know which of your former clients he has approached. You know that he hasn't moved yet, which means he either doesn't have enough or he's waiting for the right moment. You think about Harris Weld at odd hours, on a Tuesday morning waiting for a call, or in the back of a car on the way to a meeting. You think about what it means that someone is building a case against you with the same methodical patience you use against other people's problems. You think about the version of yourself that would have found this ironic and the version of yourself that finds it simply operational. There is a call you'll receive eventually from Harris Weld. He'll want something, money or credit, or a piece of the arrangement you've built. You've already decided what you'll offer him, and you've already decided what you'll do if he doesn't take it. The decision was not difficult in the way you once thought these decisions would be difficult. That's the part you think about most, in the quiet moments you allow yourself. Not the decision itself, but the ease of it. The distance between who you were at that desk at 11:40 p.m., reviewing a pharmaceutical contract, and who you are now. You are very good at your job. You are still deciding what that means. Your phone rings. You answer on the first ring.